On 23 January 2023, the Commission sent you a request for submission of the 5-year declaration of assets and personal interests. And on 27 January 2023, you submitted your 5-year declaration. The Commission also asked candidates to voluntarily complete and submit an ethics questionnaire, and you did so on 5 July of last year, 2022. The Commission sent you 3 rounds of questions on 10 April, 2 May, and 12 May this year, 2023, respectively. You were asked a total number of 13 questions, including 25 subparts, and 10 of the questions included the request for further documentation. According to Article 3, Paragraph 4 of the Evaluation Rules of the Commission, a candidate may not provide information, documents, or other materials during the hearing if the Commission requested these earlier and the candidate did not provide them within the time specified, unless, of course, the candidate provides sufficient justification. Members of the Commission will now start with asking you questions, and Vitaly Miron will start with asking questions first. We will try to keep our questions short and to the point, and we ask that your answers be short and to the point as well. Vitaly, you have the floor.
Greetings again. We'll jump straight to the issues and questions. In fact, all the issues that we're going to address today were already discussed previously. You are familiar with them, so I believe it shouldn't be an issue for you to answer them. Hopefully the questions will be simple for you and you'll be able to answer them with yes or no, and where you find it necessary, you can provide some additions to your answers. Now, the first issue has to do with the non-declaration of 2 bank accounts in 2020. with balances exceeding 15 average monthly salaries in the economy in that same year. I will start with setting the facts. In your Declaration of Assets and Personal Interests, submitted to the National Integrity Authority for 2020, you did not disclose a bank account of yours and one that was your wife's. These accounts were open and active during 2020. On the date of the submission of your annual declaration for 2020, the balance of your bank account was 81,432 lei, while the balance of your wife's bank account at that date was 108,465 lei. According to the regulation on how to fill in the Declaration of Assets and Personal Interests, the bank accounts of the declarant and of the family members of the declarant are to be reported only if the total value of all accounts exceeds the value of 15 average salaries in the economy. According to the government decision number 678 of 2019, the average monthly salary for the economy in 2020 was 7,953 lei, while 15 average salaries was around 120,000 lei. On the date of the submission of your annual declaration for 2020, the combined balance of those two bank accounts was 189,897 lei. This amount that I just read out to you exceeds the amount of 15 average salaries in the economy, which was about 120,000 lei. Therefore, your bank account and your wife's bank account, they were both to be reported in your annual declaration for 2020. In the second round of questions, you informed the Commission that in your 2020 declaration, you included all the income obtained, including the salary and allowances, and in the financial assets section, you did not include funds held in bank accounts as income you had already declared. These were the facts. Were they correct? Were these circumstances correct? Well, now I will jump to the questions. Can you confirm that in your 2020 declaration you did not disclose the bank accounts that actually had together an amount of 189,000 lei? Yes, I checked, and they are not included. They were not included. I checked the declaration, and in the financial assets section, these accounts were not indicated. Do you dispute that the law on Declaration of Assets and Personal Interests, in effect, in 2020 required the reporting of bank accounts of those required to file them and their family members if the total value of accounts exceeded the value of 15 average salaries in the economy? I would like to say the following with regards to this aspect, something that I've also provided in writing. When it comes to the regulation passed by the NIA, it was passed in 2022, the regulation, so its consequences started to be effective on the day that it was passed. As regards those two bank accounts that you referred to, my account and my wife's account, and there is a salary that I receive from my work, and my wife's is the allowance account for childcare. So it's not an external source. I mean, the source of those funds is not unknown or external. And therefore, every year we declare, at least I declare, all the amounts that we obtain, that my wife obtains as well. And in terms of a practice that used to be the case before, a practice that we used to have, that everybody would follow, is that the bank accounts that were declared as related to salaries or allowances, if they had already been declared, then you would not declare them repeatedly because they were deemed to have been already declared. I accept your answer, and indeed we can see what the nature of those accounts is. One is related to the salaries and another one to allowances. Is that correct? I mean, you did report them in that category in the declaration template, but the law also provides that in addition to the fact that you report your salary as an income, but when you have an account where you have funds above 15 average salaries in the economy, you have to, although by duplication, you have the obligation to report it in the right field of the NIA declaration template. So that was the question. We're not speaking about the source. We're speaking about this particular aspect. These two accounts together amounted to an amount that is larger than 15 average salaries in the economy, and they were supposed to be reported, but they were not. Do you disagree with the fact that they were supposed to be reported in the NIA declaration, or do you have a different understanding of this situation? For annual declarations, we have a template. The template is provided to us by the National Integrity Authority. And this, the way it is formulated, accounts where the funds are above 15 average salaries in the economy, that started to be implemented and in force in 2022. I don't remember having this provision around in 2021. Give me a second. No, according to the regulation on the filing of declarations to NIA, as I read previously, the bank accounts of the declarant and the family members of the declarant are to be reported only if the total value of all accounts is above 15 average salaries. So this is a provision, but it started to be applied or effective in 2022. The regulation is, if you're going to refer to that provision, that was enforceable in 2022. Regardless of the regulation, because the regulation of the National Integrity Authority, they've indeed been changing and been amended over time. There are different regulations, but that provision applies since 2016 from the law. It's in the law that it states that there's 15 average salaries. That is to say, can you clarify, have you always been declaring only the accounts that were not related to the salary, right? I mean, if you had a salary connected to that account, you would not declare it because you thought, well, that's what I tried to explain in my answers in writing. Previously, when we had to start filing the declarations, in the past, we would file them on paper only. So there were very few guidelines about how to work around it. And then they would all be collected at the employer, and then all together would be filed with the authority in charge of looking into them. As regards the declaration of accounts, I don't think I was the only one who acted in that way, who did what I did. The practice was understood to be that you need to declare the accounts that are other than those related to the salary, that you have funds going there from other sources. If this is regarded as something that was omitted, it was not my purpose to hide any sources of income that was already declared. Thank you for your answer, but just to try to wrap this issue up, you spoke about a practice that we've also heard of as a commission. But now, currently, do you believe that this was a mission on your behalf, or do you continue to believe that you shouldn't have, still you shouldn't have reported them? Now, considering the practice, and that I believe is a good practice, I believe now that that was an omission on my behalf. I accept your answer.
Thank you very much. Should we go to the second issue? And Victoria, you have the floor on that. Yep.
Good morning. I'm going to ask you about the apparent income and expense imbalance in 2021. Based upon information collected during the evaluation, it appears that your family's expenses were greater than your income in 2021, as set forth in a table in the fact summary that we've provided you. Your declared income for your family in 2021 totaled 623,798 lei. Those amounts are listed as declared on the table based upon your NIA declaration. As discussed in connection with the first issue, you and your wife each had a bank account that was not disclosed in your 2020 annual declaration. Since the accounts were not declared, the savings were not included as income, or were not included in the chart altogether in the Commission's written questions to you about your income and expenses for 2021. The balance on deposit in your undeclared bank account on 31 December 2020 was 37,977 lei, and the balance on deposit on that date in your wife's undeclared bank account was 111,190 lei. If we add the combined balances of those accounts, totaling 149,167 lei, you had a total income in 2021 of 813,695 lei. For 2021, based on your annual declarations, your expenses were initially calculated to total 980,000 lei, including 19,800 lei for a family member's medical expenses, 798,090 lei declared savings in cash and bank accounts, and 162,144 lei for consumption expenditures for a family of 4, according to the National Bureau of Statistics for your region. Thus, your total expenses appeared to have exceeded your total income and savings. In the first round of written questions, you stated that your expenditures did not exceed the income and savings accumulated by your family, and you disagreed with the calculation formula used by the Commission to determine expenses. You indicated that your family's bank records showed debit transactions for cash and expenses for 2021 totaling 237,331 lei. According to our calculations, the amount of the withdrawals from one account was 137,873, not 137,837 as you had indicated. So the table that we furnished you today now indicates, instead of using the CEP for expenses, which you objected to, the cash and expense withdrawals in the total amount of 237,367 lei, according to the bank records that you furnished. You also indicated that the amounts that you had declared in your annual declaration as the balances for your bank accounts was the amount on balance in each of the accounts as of the date in 2022 that you submitted your 2021 annual declaration, instead of the amount on deposit in each account as of 31 December 2021. So the table has now been adjusted to also include the amount on balance in your accounts and in your wife's accounts as of 31 December 2021. With these adjustments, your expenses for 2021 appear to have exceeded your income by 209,718 lei. So I'll begin with questions. Can you confirm that the information listed in the chart in the first 2 columns for your income in 2021 and savings carried over from 2020, are you able to confirm those amounts?
Yes, at first sight, that seems to be accurate.
Does anything appear incorrect or missing?
I mentioned previously as well, as an objection or something that I thought was not considered, that there's always a reserve in cash of a year before that. So there's a reserve up to 15 average salaries in the economy that is not mandatory to declare. So I believe that this is something to be taken into account as well in every case.
Right, and I think that you, in response to written questions, you noted that the legal provisions allowed non-declaration of cash up to 15 monthly salaries per economy, that is up to $130,000 for 2020. But you did not say in those written response to the questions that you had cash in that amount or in any amount in bank accounts, correct?
Well, you are to declare if that amount is exceeded, but if it's under 15 average salaries, you don't have to declare it.
And I realize you didn't have to declare it, but also when we asked you about the income and expenses, you didn't say that you had that amount in savings or any other amount in savings, in cash savings, that did not have to be declared.
Well, that was the whole purpose and the logic behind what I said. I did have some reserve. I never hid it away. I did not. It's only that I did not declare it because it was not mandatory to declare it. But I never said I didn't have some savings, some reserve.
And what would be the amount of savings that you had in cash, not in bank accounts, at the end of 2020?
In cash, I cannot be now very precise, but it was not more than 130,000 lei.
Okay, can you confirm the amount listed as expenses in the third and fourth columns in the table?
I can confirm fourth column, indeed, the withdrawals from accounts, and then expenses for healthcare services, and then the cash accumulations are correct. And when it comes to accumulations on the bank accounts that are established there, I believe they cannot be regarded as expenses because they've been accruals there, accruals of funds, accumulation of funds.
Right. And I understand that you agree with treating them as expenses. I would encourage you in there's an annex in the Commission's evaluation rules that explains and cites the ECHR decision that explains how these calculations are done. And we are not calling your savings accumulations necessarily as expenses. It's just a comparison of what you started the year with and what was left at the end of the year, given expenses that were withdrawn and income that came in. That's just, those are separated into separate columns. But I encourage you to look at the ACHR decision for how the calculations are done. And you are able to confirm the amount of expenses. So if we accept all of those calculations, there still appears to be a discrepancy between your total income and carryover savings into 2021 and with what was left with the end of the year. Can you explain that?
No.
Yes. First of all, in 2021, there is an additional source of income, the funds that were earned out of the sale of the car, and that is also included in the table. Well, following the sale of the car, there was a reserve of cash that we had from the previous year. And therefore, there were two debits from the bank account, my salary account and my wife's account for allowances, and in total there were 237,367 lei. So, as I previously explained, and I continue to be of the same opinion, that this relation between income and expenses, well, you see there are accounts for accumulations. Like I said about the personal allowance, the child care allowance account, that is an accumulation account. When I say that, I mean that we don't spend money from there, as is the account of my wife who receives some allowances from Romania. We don't touch that money, we don't spend that money. And you can see easily that the accounts that are declared, the accumulations there are made on the basis of allowances. So that's what they're made of, allowances that are paid to us, and they are accrued there in those accounts. If we look at the expenses, the withdrawal of cash, 237,000 minus, and if we subtract the services, then we have a balanced relation, including the maintenance cost, the CCP that was previously included of 164,000. But even those calculations regarding the expenses for family maintenance, I believe that they're rather approximate, they're rather estimates, not very precise figures. So as a family, we've always tried to make some savings to save up for other purposes related to our future. And the expenses that are here, even the withdrawal, the cash, the one related to cash withdrawal in cash, and the cashing out, that is, and considering the expenses that a family can have in a year, I think that this is quite well balanced. Even the relation between the accumulations in cash, should we make a simple calculation? And if we include the sale price of the car and the cash, I'd say that things are balanced out. I believe there wasn't a big amount of cash accumulated in the budget of our family.
Is there anything else you wish to add or clarify about this issue?
What I would like to mention is that indeed we did not have other sources of income that needed to be declared. We cover our living costs with allowances and salaries. And I think that when it comes to this relation between income and expenses, although I'm not a good accountant or economist to try to provide a justification properly for that, but looking at the amounts that were cashed out and withdrawn, I believe that we were thus able to cover our maintenance living costs that we had to incur in 2021.
Yeah, and Nadia, go ahead. Yeah.
Just to try to perhaps bring more clarity, it might be indeed harder for lawyers to work around figures. Still, all these figures are based on banking records, on banking data. So what you could challenge, what one could challenge is rather the cash savings. About cash savings now, do you disagree with the amounts that are stipulated there? Maybe is that correct, or is it not? Because when we're making the calculations, just to make sure that it's clear with the expenses and what Victoria said, and it's also very clearly written in our evaluation rules, the Commission calculates what was there in the beginning of the year and what was left at the end of the year. And what's in the account at the end of the year, December 31st, that is regarded as an expense, say. So we're looking at income and expenses. So that's how we look at it, what came in and what left out of the account. Incoming, outgoing. So if you don't disagree with these amounts, because this information was taken on the basis of your bank accounts, according, and now then if we look at your savings in cash, because is it about the cash savings that you said they were not quite correct? What I'm saying is that I had cash savings, I just didn't indicate them, because for 2020 you didn't have to declare them unless they were above a certain level. It might have been an omission because the balance of bank accounts for 2020 2020 wasn't taken into account for us to see the dynamics of that. But in terms of an analysis of bank accounts that are indicated, and now of late it's easy to check things on the bank accounts. You can see that there are accruals due to salaries and allowances. There are no other sources of income. What about your cash savings? Can you tell us what is the approximate amount of the cash savings? There was in the table, there were some amounts in the table, and it seemed to disagree with that. Did you have fewer savings at the end of the year, fewer cash savings at the end of the year? For the declaration, but we're not speaking about the declaration. I am just asking you about the table. You have there in the table a figure that is supposed to represent the cash savings according to the available information the Commission calculated that amount. Are you saying that you had smaller cash savings at the end of 2021? Is that correct? Is that a correct understanding? But there is another nuance to it that I believe must also be taken into account, and that is the fact that the amounts that are indicated as cash, you have to declare it at the date when you're filing the declaration. And as far as I remember, I declared in March at some point. That could have been some cash, for instance, related to that period of 3 months. It's not excluded. That's exactly why I'm asking about it. Out of all those amounts, the ones that are not that clear, it's the cash savings. And I'm asking whether you challenge, whether you disagree with the figures in the table. And then at the end of 2020, at the end of 2021, having a look at that, is there anything that you can tell us about, say, an estimate of how much cash you had at the end of those years? How much cash did you have? If I did not declare in 2020, it means it was less than 130. It could have been 120,000, could have been 125,000. It was less than 130. That's your position, both in 2020 and 2021, or only 2020? For 2021, at the end of the year, it could have been under the amount that is indicated here, because I declared it at the date on the date of declaration of submission. And in speaking in estimates, you don't remember how much it was. I can't tell because I evaluate it, I assess it at that moment in time, and I declare it immediately. So it's up to that date specifically. And at the end of 2020, you were saying that at the end of 2020 was under the level that would have otherwise demanded that you report. It was under 130,000 for certain.
Just for clarification here, the amounts listed in the right-hand column as cash savings at the end of 2021 was 227,354 lei. And in addition, we have the amounts on deposit in your bank accounts that start at the beginning of the year at 151,561 lei, and at the end of the year are 498,162 lei. So your savings, assuming you had something of 130,000 lei or less in cash savings, that grew to by 100,000 lei by the end of the year. And we know the amount that increased in your bank accounts. We have the expenses. Where did the other 100,000 in cash savings come from?
If I may, I will try to explain it in simpler terms. So, making some simple calculation, holding cash around 130,000 plus income that mentioned 77,304 lei, we form an amount that is over 200,000 lei. As you can see, 227,000 lei could be the difference related to that 3 months period, or maybe the differences caused by cash savings based on withdrawal from bank accounts. Out of this amount mentioned here as withdrawal from bank accounts, 237,000. So I had the expenses that we incurred for medical services, 19,000, let's say 20,000, and we are left still with over 200,000 that was disposable to my family for expenses. and expenses as transactions or cash savings. So I think that this amount gives very real expenses of a family without taking into account the money on bank accounts that was gathered over the years. It did not just happen from any other sources than the official ones.
No further questions.
Anyone else on this particular issue? Okay, then we move on to the next topic. Vitaly, go ahead.
Disciplinary procedure, that is also an issue that was approached in the discussion of the Commission in 2017. The Superior Council of Prosecutors passed the decision of 30th March 2017, issuing a disciplinary sanction of warning to you. The decision was issued as a result of controls relating to alleged inactions and delays by you as Deputy Chief Prosecutor of Cantemir Prosecutor's Office in leading criminal investigations in 5 cases. The disciplinary decision imposed the sanction for you for the way you handled 3 of the criminal cases. Criminal case number, let's make it 802, because I think you know about that case. I will just use it a shorter name for it. So it started on 26th of March 2015 based on Article 217 prime paragraph 3 letter B and F of a criminal code, and that is illegal distribution of drugs, ethnobotanicals and their analogs for purpose of sale. However, between October 2015 and August 2016, which is 11 months, this criminal case was left dormant without a complete and objective investigation being undertaken into all aspects of the case in order to find the truth and take appropriate actions to administer evidence and finish the criminal investigation. The decision stated that the inactivity in this case was you were passive in performing this investigation, and the results of the control stated that the prosecutor was indifferent and extended the term of a criminal investigation, issuing order with similar content. On 4th of December 2015, you formulated written instructions which were ignored by the criminal investigation body. Even in these circumstances, you did not react according to the disciplinary decision. And then, criminal case 448 started on October 22, 2013, based on Article 352, paragraph 3 of the Criminal Code, arbitrariness that led to violation of public order or violation of rights of other people. You conducted the investigation until 22nd of August 2016. But between 19 February 2014 and 26 September 2016, except for the addition of some documents to the case file materials and providing an instruction to the criminal investigation body, which did not carry out the necessary actions according to the disciplinary decision, you just issued formal template orders to extend the terms and did not respond to the fact that the case was left inactive. Criminal case 026 started on 10th of March 26 based on Article 362 prime paragraph 3 letter A of the Criminal Code, and that is organizing illegal migration. And until 10th of September 2016, you were the one managing the case. The decision stated that because of the prosecutor being passive, and you did not undertake any actions regarding that case for 2 months, the term of criminal investigation was formally extended by orders with similar content without formulating written instructions. You formally extended the defendants the preventive measure not to leave the country, but you did not inform the border police or the police authority where the defendants lived, which resulted in spending time and resources to conduct investigations in order to find the accused. So according to the decisions, analogous situations were found by verifying your other criminal cases that you managed. So the decision stated that you were guilty of violating responsibilities specific to the office expressed in the imperative requirements set by Article 6, paragraph 3, letters A, C, and D of the Law on Prosecutor's Office, according to which prosecutors are obliged to perform their duties in strict compliance with the Constitution and the laws of the Republic of Moldova to ensure respect for human rights and fundamental freedoms, fundamental rights and freedoms in the exercise of their duties. respect the deontological rules of prosecutors and to refrain from acts that would discredit the image of a prosecutor's office or affect the prestige of a prosecutor's profession. In the ethics questionnaire submitted to the Commission, you stated that the disciplinary sanction imposed on you took place during a period of withdrawal criminal cases from territorial prosecutors and transfer of cases to specialized prosecutor, where tendenciously, without any complaint, several prosecutors were subjected to disciplinary proceedings for non-compliance with a reasonable timeline. Although the data in the Prosecutor's General Report in 2017 reflected thousands of files with investigation timelines for over 3 years, you noted that the files that were subject of a disciplinary decision were in procedure of other prosecution bodies directly responsible for the criminal investigation process, and deviations by them were not found. So the trials were complex, and the criminal prosecutions were completed years after you were sanctioned, but no one was interested in that. In response to written questions, you attached a copy of your appeal to a disciplinary board decision that you submitted to the SCP, where you provided details of all your arguments. You also stated that personally you are very much affected by the arbitrary treatment of a case by the collegiate bodies, by the superficial attitude towards your effort, and that form of persecution against you, which can be appreciated from can be understood from the audio recording of the SCP meeting. You stated that when adopting its conclusions, the Discipline and Ethics Board did not take into account the measures taken by you regarding the efficiency of the criminal prosecution, as well as circumstances related to the criminal prosecution process, namely adopting written directions by you for criminal investigation body, performing joint meetings with representatives of Police Inspectorate Kantemir and Criminal Prosecution Department, where you discussed the issue of delay, constant change and lack of staff at Kantemir Police Inspectorate, including change of 3 investigators into criminal cases, lack of staff in Kantemir District Prosecutor's Office, including 3-4 vacancies of prosecutor positions for long periods, the workload of Kantemir Prosecutor's Office, including the amount of each individual prosecutor, the fact that all listed criminal cases were under direct management of a Kantemir Police Office and Border Police, which independently issued decisions on investigations and of cases and what actions were supposed to be taken, lack of complaints from the parties in the criminal cases about the investigation or prosecution, the negligent attitude of Kantemir Police Inspectorate, where it was investigated internally and violations were found but disciplinary sanctions were not issued. By the Superior Council of Prosecutors decision number 123317 of 30th of March 2017, the Disciplinary Board decision number 132517 of 25th of February 2017 was cancelled, and a new decision was adopted with a disciplinary sanction in the form of warning. I will start by asking you some questions in order to ascertain the facts. I hope you will be able to answer by yes or no, and later on we'll try to get into more details. So with respect to the case 8002, the first one that we mentioned, you probably have a factual part, and it is mentioned. So the decision states that the case started on 26th of March 2015, but that between October 2015 and August 2016, which is 11 months, the criminal case was practically left dormant without a complete and objective investigation being carried out into all aspects of the case in order to find the truth, without taking appropriate actions for the administration of evidence and in order to finish the criminal investigation. The decision states that you have extended term of criminal investigation, issuing orders with very similar content. On the 4th of December, you provided written instructions which were ignored by the criminal investigation body. Even in these circumstances, you did not respond according to the conclusion of a disciplinary body. And some questions to clarify. Are any of those facts incorrect, the ones that I read about this criminal case on this part? Only one side of the investigation is expressed here, but not all arguments that I provided when I wrote the appeal. And I can explain them. Well, was the defendant under arrest during that time, October 2015 until August 2016? From what I remember, initially, yes, but then the preventive or pre-trial measure was cancelled. In this decision that I mentioned above, a delay is found, like 11 months delay. Do you believe that this delay is a violation of your duties? I don't believe so, and I will tell you why. With respect to the extension of the criminal investigation timeline at the suggestion of a criminal investigation body, the prosecutor is obliged to issue an extension. Otherwise, the process cannot take place aligned with the criminal procedural provisions. 11 months, I think the 11 months here is the entire time of the criminal investigation, because all actions were undertaken during 2016 until the spring of 2016, and as a result of searches, a lot of objects of unknown origin were found, around 60 objects, and these are material goods, some identity documents and other objects and records that needed to be checked as potential involved parties or potential consumers of drugs, or generally how these acts or records could be at the domicile of the people who are part of a case. That was the main reason. When it comes to the performance of the criminal investigation in inquiring into such a case, maybe it was not always to the extent of the expectations that happen always, but because there was a shortage of staff with police as well. Therefore, to order the withdrawal and ask for another officer, I thought it was inappropriate, because it was a kind of high-profile case. It lasted for several months, and if we changed the investigation officer, it would take even much longer to finalize that case. The question final question about this case. Anyway, do you think in your action, was there anything that led to the delay in this case? Because 11 months, and you said that it was a high-profile case. So I want to understand precisely, do you believe that because of Prosecutor Eduard Panea, things were done or not done, which led to delay? As a prosecutor, I always took all measures that depend on me in order to apply the criminal procedural law. Even in the appeal that I filed with respect to the decision of a disciplinary board, the criminal investigation was almost finished on that case. So it was not a case that was abandoned somewhere and forgotten. And based on data that I personally checked, during 2 or 3 months after withdrawal, it was sent to court. Of course, it was going to have the same solution by me in case of I continue to examine. I accept the answer. With respect to criminal case 0448, you have a factual part. If you want, I can give you the crime elements, but you probably know that. The decision states that the case started on 22nd of October 2013, and that between 19 February 2014 and 26th of September 2016, that's 2.5 years, except for adding some documents to case file, formulating some instructions for the criminal investigation body, which actually did not carry out the necessary actions. You just issued some formal template like orders to extend the timeline of criminal investigation, and did not respond to the fact that that case was left inactive. These findings that I read, are they incorrect or are they true? I believe they were not true, and I will explain why. Please do. This is about a case that I received from another territorial administrative unit, from another prosecutor's office. So I respect the timeline of assigning the procedural status suspect or accused to the parties that were involved, and all procedural acts that were related to the performance of a criminal procedural action, they made a plan of the criminal investigation that was supposed to happen regarding that case. I don't think this formulating about template-like documents that were used almost in all cases, because the prosecutor does not issue any template type documents, because the prosecutor creates the document in that moment when they issue it, given the situation as of that day in relation to that criminal proceeding. I can say more. But once I was transferred to the anti-corruption prosecutor, I happened to continue the criminal investigation and prosecution of that case. It happened so. But the facts that were invoked in this fable are related to many other cases, and at least I would like to mention that at some point three cases were joined to this one, together with this one, and they were related to several other criminal cases that were being managed by criminal investigation bodies. I cannot state how many, but there are data available, and they were being examined at some point. The issue of this case, that was an insolvency proceeding that was much more complex than just an episode that is described here in this case. And depending on the development of that insolvency process, behavior of the participants, because the parties involved there were all, well, mostly against conducting the investigation without providing any support, and during a long period of time it was even difficult to find the injured party on that case. They did not want for the injured party to be involved. This case was, and maybe it is, I don't know if the process is over yet, because since 2020 I have not been working in anti-corruption, but I believe that this it was related to many other acts that needed to be examined in parallel. Thank you for your answer. Just a clarification. And I'd like to mention that the approach with formal and template-like orders is just a finding that we found in the decision of the SCP. It's not us making such conclusions. So you said it was a complex case, then you said that according to the amount of availably provided information, and it was complex. We have access to your statements and the findings of the disciplinary board and SCP regarding this disciplinary control. Could you, in simple words, well, to the extent possible, also taking into account your position as prosecutor and if the cases are still pending or not, could you please tell us what was done in 2.5 years with that case? From the moment it was taken to procedure for 2.5 years, almost no work was done on it. I mean, what happened? Why 2.5 years? Why it was inactive? It was not about being inactive. I want to speak from a perspective of my position as a prosecutor in this process of prosecution. At every stage, I was issuing written indications towards where this indication could lead for us to gather materials, or depending on each step, if something changed in the development of the events. There was information that was gathered during that period of time, but the major issue was the attitude of a criminal investigation body, which with all leverages that were used, but they did not always obtain results. Saying now that it was a complex case that they just couldn't handle, well, that may be, this version may be possible. I cannot state exactly, but I think 3 criminal investigation officers were changed to manage this case. So we always try to improve the situation, but it did not lead to results. Your answer is accepted. In the same context, the same direction. Criminal case 2026. The decision states that the case started on 10th of March 2016, and until 10th of September 2017, you were the one managing the case. The decision clarified that you did not undertake any actions on this case for 2 months. The term of criminal investigation was officially extended by orders with similar count without any written instructions to the criminal investigation officer. You formally extended the preventive measure applied to defendants' obligation not to leave the country, but you did not inform the territorial police authority or the border police where they lived, which resulted in waste of time and resources to conduct investigations in order to find the accused. These facts, partially or integrally, are correct. Do you disagree with any of the things mentioned above? I believe it is not correct, and I will explain you why. First of all, the criminal investigation until September is not correct. I led it until July. And after vacation time, I was transferred to another institution, so I couldn't have managed it until September. So the time while I was the one leading this case, that was about 3 months. Believe me, a huge amount of work was done. Given that there were 4 or 5 persons involved, special investigation actions were orders, and I finished them during that time. In the appeal, I wrote that they issued 55 orders to obtain data about their bank account turnovers resulting from the criminal investigation, and as of the date of the control, they were being executed. They were not finished yet. With respect to such statements that I did not inform some bodies, it's not true. All measures that were ordered were provided as information to the border police as well, because the case was carried out by that body. It wasn't just a foreign organization that did not know anything about it. And there were other mechanisms that were used to apply restrictive measures during that time. Your answer is accepted, but I would like to know exactly if I understood you right. The findings that I read, again, those are... That is a segment of the decision of the SCP, or what is mentioned there. And I found in another criminal case, and now you say that the information there is incorrect, and you disagree with it. It is partial. It was expressed as a part of it, but it doesn't show all the ways how to counteract it. But then, okay, a clarification regarding this case. In the decision of the SCP, we find precisely the information that prosecutor that was handling the investigation of that case, you did not take necessary actions with respect to informing the police inspectorate and the border police about the assurance measure. I think that's the right wording, meaning the prohibition to leave the settlement. Well, in this respect, a disciplinary action was after I left. The chief prosecutor performed the disciplinary action where it found violations by the control body. I'd like to state more. These disciplinary proceedings went together with another person, and that is the chief prosecutor. We were both envisaged on the same criminal cases, on the same aspects of violation of reasonable timelines. And the arguments that the boards used I mean, we have some joint arguments because the cases were the same and the effort was the same to undertake the actions and to respond to all violations. So with respect to him, the board accepted them as pertinent and reasonable, but with respect to me, they say that we're contradictory. Before moving to the next question, I would like to ask a question to make sure that I understand the case exactly. So there was a disciplinary decision by the decision of February 2017, so you were issued a reprimand action. You disagreed with that sanction, you disagreed with that decision, and you filed an appeal with SCP. The reprimand was in the ruling part. Well, what of the reasoning was contradictory? Yes, that was one of the arguments of SCP, why they amended the sanction, including this one. Because everything imputed to you sound as a warning, but in the ruling part they stated reprimand. So you disagreed with that disciplinary control, you disagreed with the solution, with the sanction, and you appealed it as provided by the law. For several reasons. Your appeal was accepted partially. Some things were found, a different sanction was applied, a warning. And from what I remember, in a way or another, you said that you're sorry for what you did, you proved intent to improve, and you asked for a milder sanction. Is that correct or not? I don't know where you have this information from, because for that entire period of time, normally all minutes of the meetings are public. They are published on the website of the institution. The minutes of a meeting was published, but it was redacted in the part of questions and answers. This sequence that I read, that is from the decision of the SCP of 30th of March 2017. And I want to understand that if you partially disagree with some facts written there, including the fact that you were sorry for what you did, I was asked, why didn't you appeal it? If you disagreed with it?
Also in part.
In totality or in part. That was a complicated time at work as well, right around that time. I think it was more about the fact that there was trust. They had trust in the collegial body, that they would bring clarity and they would dot the I's and cross the T's with regards to all of the topics that were addressed. At the meeting, I provided a lot of justification, more than what was written in the written part of the challenge of that. And I think that is rather, the way you put it is rather an interpretation of what was said. So it was quite peculiar for me to even look into the minutes to see whether they indeed worded it like that. I am not aware about what was written in the minutes of that particular meeting, and that's why I asked that the recorded hearing would be listened to. So at this moment in time, I cannot speak as to the genuineness of those statements as far as my own words are concerned. I accept your answer and a couple of other questions regarding this matter. Is there anything that you would like to tell us about your workload at that time when this disciplinary issue happened? I would like to provide some details regarding that. And could you tell us about the workload of Eduard Panea? How many cases were you working on compared to other prosecutors of that same institution? Around that time, I was a deputy of the chief prosecutor of Cantemir. And as a deputy, compared to other positions, my workload, I believe, was normal for that time. However, we have staff turnover. We were always missing about 3 or 4 members of the staff, and there were 7 of us on the staff establishment, and we would always have some 3 or 4 vacancies. In terms of the workload, I was responsible for criminal investigation, carrying out criminal investigation at the prosecutor's office. There were about 10 cases turned permanent cases. Permanently, I would have about 10 cases to work on. When it comes to leading criminal investigations, at the time there were about 150 cases, and every month some actions had to be undertaken with regards to them, some review, some examination. Now, speaking again about workload and my dedication in that period of time, I can say that I continue to have still leave days or days off from 2014, which is indicative of the fact that I dedicate a lot of my time to my work, to the detriment of time that I could have otherwise spent with my family. Now, with regards to these 3 criminal cases, at the end of the day, you're being blamed for delays in the examination of those cases. Are you aware whether some of your decisions, some of your actions were challenged, or whether the hierarchically higher prosecutor took other decisions, or the court took other decisions in that regard in relation to those 3 cases? Well, as I said, one of them had already come to an end at that time. As for the other 2, in 2020, I found out they did not reach a completion stage yet, which meant that they were still under review, but without my participation in that particular case. Regarding the other aspect, the second aspect of your question, as to whether some of my acts were annulled, I can say that none of the documents that I personally issued was annulled. It was neither by the hierarchically higher prosecutor nor by the court. And there was no request or no decision that would have pointed to me as having delayed the criminal investigation. And as I also mentioned in the written Q&A rounds, that it was regrettable that it was only in 2020 that the law of the prosecutor's office had started to have the gross negligence definition and term. I think this should be looked into when appreciating whether there is disciplinary violation. But such a provision did not exist back at the time when those issues happened that you asked me about. And what is more, or the action or inaction that are imputable to me, or presumed to be so, they should have led to a particular harmful consequence, but I believe that was not the case as far as I am concerned. I accept your answer, and this is something else that I wanted to ask you about, whether you were aware, because at the end of the day, they are blaming you for delays in the criminal investigation in those 3 cases. Are you aware of their further fate? What happened to them? What ultimately happened in those cases? Out of the public information on the website? When it comes to illegal migration, there is a decision of 2020 of the court. So then there is the 2013 case about insolvency. But I don't know about that. But in 2020, at the time of 2020, the criminal investigation wasn't over yet at that time. So it was still underway. As for something that could be imputed to me personally for some violations or admission of violations whatsoever, that didn't happen in these years, over these years. Thank you, Mr. Panea. Now, last question, and if there's anything else you would like to add, you will have the opportunity to. But before that, I would like to say that to me personally, given that there is a disciplinary procedure, and that a candidate, that there's something that is imputed to a candidate and a sanction is applied, then it makes me wonder who was the one who initiated the disciplinary procedure. How did it come about? How was it reviewed? Was there a complete contestation whatsoever, and what happened with that? I do believe these aspects are important. So can you tell us, please, what are the circumstances amid which the disciplinary procedure was launched? And if you challenge the decision of disciplinary board, is there anything more that you can tell us? What materials did you produce? How long did the hearing take? Because I feel like you don't agree with some of the findings in the decision of the board. You disagree with some of the findings in the SCP decision. Can you tell us why is that the case? there was a referral, a notification from the criminal prosecution unit from the General Prosecutor's Office when there were certain categories of files around, and depending on their elements, they would be, for instance, withdrawn or referred to specialized prosecutors at that time that was happening. So the notification with regards to myself, I think it's not longer than a page and a half. The text there is not that big, and it focused mainly on delays according to Article 2259 of the Criminal Code of Procedure. So there are some regulations that provide for the different terms that have to be observed in a criminal case investigation, but not as a consequence in terms of violation. There are some other rules that apply and that regulate, that cover the deadlines and the other consequences that might apply if there's a violation or if certain actions are not carried out, although they should have been carried out by a particular deadline. But it was not that was imputed to me in the procedure that was initiated against me. So when I also provided written explanations to the board, and in those written explanations I provided a wide range of details, because at the time, of course, I recalled all the events that were taking place. I don't think it took, though, the hearing, I don't think it took more than a few minutes at the board. I think there were some preconceived ideas that they rather had an attitude of accusation against me rather than a readiness to hear my arguments and what I had to say. Now, you already know what the contents of the decision are, and it's quite contradictory. I did not really grasp it. Still, in that decision, they also provide some of the arguments that the chief prosecutor used at that time. He was also a party to that disciplinary procedure, and that they are regarded as reasonable and they are accepted. In my case, though, the contrary happened. As regards the challenges with the SCP, that was a lengthy procedure. It did take some time. It took about 40 minutes. That was the rounds of questions and answers, and I answered absolutely all questions. I also provided the required justification, I believe, and I did not see them in the, as I did not see the minutes, I don't know if they put down everything that I said. If I saw it at that time, I could have said, for instance, that that is exactly what I said. As regards the solution and specifically the violation referred to in the decision of the SCP, so they said that there was a delayed settlement of criminal cases and lack of promptitude. And as for delayed settlement, you see every case is specific in its way, and there are certain deadlines that you have to abide by. But at that time, all criminal cases, they were not accompanied by any proposals or suggestions to the prosecutor as to by when to finish reviewing a particular case. Otherwise, how can they say that it was delayed if the process was underway, if work was underway? And as I said, in certain instances, it took more years, a number of years, even after I was no longer there, even though I was not any more responsible of those cases. As the lack of promptitude or not acting promptly, I believe that was not an adequate appreciation, because the Law Prosecutor's Office, and according to the Code of Criminal Procedure that was in force at that time, allowed us to only put down some sort of a referral or notification to the employer for a disciplinary control to be carried out and to be looked into, so that they could look into the actions of the prosecutor. But there would be written instructions, for instance, by the prosecutors, or what could happen also would be withdrawing the case from the prosecutor. There would be these operative meetings with minutes that would specify all the important aspects. Written notifications would be filed to those in charge of criminal investigations. And once the law came into force, it also provided for some disciplinary procedures that would apply in the different cases of issues, so to speak. No other questions. Greetings, Mr. Panea. Let us try to bring more clarity into this matter. So the disciplinary procedure was initiated against the chief prosecutor and against you as deputy prosecutor. Is that correct? Yes. The facts were detailed, and they had to do with the same cases. So same cases for you as some cases for him. Is that correct? Yes. Out of the decision of the disciplinary board, we can see that there were no component elements of the disciplinary violation. So he was let go, so to speak, and you were sanctioned for the same cases, so identical situations. How can you explain it? To be honest, as for the decision regarding the chief prosecutor, I don't know about it. I did not read it. Maybe it was lack of interest, or maybe for me, there was a time when I didn't want to know anything at all about the procedure anymore. I wanted to just erase it from my memory. But because of the control procedure, now I had to go back into that time and remember a number of actions that happened at the time, of events that happened at the time. And I can't tell. I mean, this, as I told the Commission, we both communicated practically the same arguments, the same justification, the same rationale. And those arguments did not have to do with me personally or with him personally. They had to do with the criminal investigation. In one case, they were accepted as assessed and deemed positive, and in my case, they were not. But did it happen in one and the same hearing? Well, we were heard separately. So it was one and the same hearing or meeting of the disciplinary board, but you were heard in turns. Who was the first one? Was it him? Yes, he was the first one who was heard, and then you were heard the second. And that was followed by a decision, and he was not charged with anything, he was not penalized, but you had a disciplinary sanction imposed on. Is that correct? Yes, and this is provided in writing in the decision of the SCP. That is, as far as the fact that the chief prosecutor's case was filed away and mine was not. Thank you for your answers, Mr. Plevan, but I have another question that I would say is a little bit more general in nature. Now, these three cases that we refer to, they seem to be quite complex. The first one has to do with illegal smuggling, well, the smuggling of drugs, with movement of drugs, correct. And when there was a notification regarding this, you were looking at the case for about a year and 5 months, isn't that correct? 26th of March 2015? Oh, no. Yes, actually, until August 2016, is that correct? And in that referral with regards to you, it says October 2015 to August 2016, 11 months. So 11 months. And the case in that time was idle, they say. You are experienced, and certainly you know what comparable statistics tell us. Now, on the basis of what you know, 11 months for a case of that complexity, is it uncommon? Is it out of the ordinary? Is it something that would usually require supervision, control, disciplinary procedures, or is it a duration that is ordinary, so to speak? I think it's not too long, and I would like to explain that. So that was a complex case that the prosecutor and the criminal investigation body was looking into, and there were several people concerned there, and special investigation measures were taken. And there was even an undercover operation. There was wiretapping, and many other measures were taken. Now, during the work conducted on the case, there was always something coming up, different versions of the story, different people being involved. And it was presumed and believed that they could be part of a criminal group organization that was to be investigated. But as more and more assets would arise, and we had to analyze that and to review that, and to considering all of those actions, it was 11 months was reasonable. And regarding that case, you say that you know that it went to court in 2020, or do you mean the third one? I said that even in the appeal, I said that at the time of the control, the criminal investigation was already coming to its end, and within a couple of months, it had come to an end. But was that case with you under your management, or was it taken away? It was taken away and went to Pechacox, which is the body in charge of this sort of cases. And I think that happened in around 2016. So it was taken away from you. And then after that, a complaint was filed. Yes. So in August 2016, it was taken away from you and then sent to Pechacox, and the disciplinary procedure was initiated afterwards. Is that correct? Around that time. All right, understood. And the other file, the other case, is lengthier. It took a little bit longer, and I would like to know whether you provided an explanation regarding that, because initially reference was made to arbitrariness, but you said that in fact that had to do with something complex related to insolvency. Is that correct? Yes. And you're unaware of that case. You don't know whether it made it to court or not? I said that out of what I knew, as at 2020, criminal investigation was not finished regarding that case. Thank you. And the third case. The third case was rather, so that seems to be about illegal migration, and a complaint, or well, what was imputed to you was that for 2 months no action was undertaken. Is that correct? As I mentioned, there were 55 orders with regards to bank turnover. So we were working on that. We can't say nothing was being undertaken. And as far as you know from the public information, that case made it to court in 2020? Well, as far as I know, yes, 2020, fine.
Yes, please, Victoria, go ahead.
Yes, and since that time in 2017, have any issues regarding delay in your handling of cases been raised since the disciplinary decision? Even if issues haven't been raised by any, have you been aware of any problems being raised by your superiors or anybody else with regard to delay in any cases that you've handled?
No, not at all. Actually, my colleagues would seek some advice regarding criminal investigation. They would ask me about some details that I was able to provide explanation for in that period of time.
Yeah, I have one question myself. When you were talking about the disciplinary board's hearings, so the chief prosecutor was heard first, and then you were heard, and these were very short hearings, just a few minutes, you were saying, is that correct?
Yes.
And after you left the hearing, were you then at the same day notified of the outcome, or was the decision in writing later?
The decision came later, I think within about a month or about a month later.
But directly after the hearing, you were not notified about the immediate outcome of the decision that the board was about to take?
No.
Okay.
No, I was not. That was not discussed. I was not told.
By any of the candidates? If not, then we go to issue number 4. Yeah. In this case, we would like to go into a closed session. No further questions? If that is not the case, then I think we come to the end of the closed session, because this topic is now finalized, and so we can now enter into open session again and give you the opportunity to make a closing statement. So please go ahead. But this is now in open session. Yes, Victoria? Yeah. Let's check whether. Yeah. Good point. Yeah. Okay. Then please go ahead in open session now for your closing statement.
Thank you. To me personally, this pre-vetting experience was a challenge concerning my professional reputation, because it was also sort of a resistance test as well. I believe that any prosecutor is also an individual, a natural person who has a life, has a social life, a family life, and often when it comes to not wanting to talk about personal aspects. It doesn't have to do with wanting to hide something away, but there is the reason to protect the closest people to us from being publicly discussed. Their expectations from the Commission are that there's going to be fairness in the way that we are evaluated, with respect for one's privacy and intimacy. As I am here today, I felt it on my own skin. I went through all of these rounds of questions. I believe these were all very important to have a discussion about, to learn more about. Considering all the hard work, I would like to say that I appreciate the work carried out by the Commission and their support team. I'm grateful for all the efforts invested and all the work of going through one's personal information, and as regards the changes in prosecution, the prosecutor system, and all the dynamics of the prosecutor system, I think I was looking forward to better things, to this, regardless of all the obstacles and hiccups along the way, and that I did my best to overcome. Otherwise, I want to wish the best of luck to my colleagues, and it is my hope that this whole activity will set the foundation for a better future system for evaluation of all the prosecutors in the country. Thank you.
Thank you very much. With that statement, we come to the end of the hearing. I thank you again, Mr. Panea, for the questions that you answered in writing, but also today in our hearing. The Commission will now withdraw for its deliberations, and as much as possible, the Commission will strive at issuing a decision within a month after the date of the hearing of today. I thank you again. I hereby declare this meeting and this hearing closed. Thank you.